So my background is, I came back to Legal Aid Ontario about three years ago to help with what was called the Panel Standards Initiative for the refugee lawyers, specifically to develop a mentoring and training program, and some of which involved technology. So thinking about the theme of this conference and my own history and upcoming 25th anniversary as a lawyer, I am not a dinosaur. But I do remember doing research as a very young lawyer for my own mentor and running off to the Great Hall to look at dusty books, not the internet. So anyways, just that's my own little musing and reflection. But so the reason for this Panel Standards Initiative was that between 2008 and 2012, there were at the time about 2 lawyers who had represented about 600 refugee claimants from Hungary with abysmal success rates. Both, and later a third, were all found by the Law Society to have committed systemic professional misconduct in their representation of these Roma minority claimants. There was an attempt to appeal by one of them that was just flatly refused this week. And in looking at that decision, I was aghast to see that there had been 18 days of hearing, let alone the resources into the appeal. The impact, of course, was tremendous. This one lawyer's success rate was so low, it was 1.2% compared to another average member of the legal aid panel who had over 30% success rate for his claimants. Sean Rehag at Osgood has done some statistical analysis of the success rates of various countries, and board members, great research, but I think that Hungarian claims are up in the mid-60s right now in recognition of the deterioration of human rights against the Roma abuses. So this individual had only 6 refugees accepted in this time period, but was paid over $1 million by Legal Aid Ontario. I think the average cost at the time was about $2,000 a claim. It's now up around $2,800. Shocking. So obviously, Legal Aid, did they have a responsibility to ensure that what they were paying for had some quality to it? But before we get to that, in addition to this financial cost, there was enormous human cost in the claims of those involved in representation by these lawyers, many of whom were deported. There was this one particular family, you may have heard the story in the news, the Priscilla Family, that were represented by the one of these 3 lawyers. He met them for a total of 3 minutes. He did not attend the refugee hearing. Most importantly, the father and the family gave him a letter that confirmed that he had done human rights work for a European Member of Parliament. The letter was neither translated into English nor submitted to the Refugee Board, and his participation in this human rights work had been the basis for their harassment, and this was not believed by the Refugee Board. The claim was rejected. So to avoid deportation at the time and in fear for their lives, this family spent 3 years living in a church in the West End of Toronto in sanctuary, waiting for justice. The Law Society's finding against their lawyer finally helped convince the government to let them stay in Canada, but this is just one example of the suffering from such terrible representation. And there were many others not so fortunate, and I forgot my water. Is that another sign of liars that they get thirsty?
Definitely.
Oh, I really am happy to be here. No. So something had to be done. And it wasn't just those 3 lawyers. There were community workers, refugee advocates who were complaining about a poor level of representation for many lawyers at the time, or for some time. So the need to act was also particularly acute because changes to the law at the end of 2012 resulted in the removal of safety nets for refused refugees. They had less time to prepare their claims, claimants from different countries you may have heard were treated differently in terms of having appeal rights, not having appeal rights. And all of this just made the consequence of poor lawyering even worse. So it had to be done right the first time. So enter the Panel Standards Initiative. And by the way, I'm not officially here on behalf of Legal Aid Ontario, I'm just me. But I am giving you the straight goods on what happened. So in 2015, all refugee lawyers, in order to do refugee work and accept legal aid certificates, had to apply and have their work evaluated anonymously by peer experts. The outcome was they would either be fully admitted onto a general and appeal panel, or they'd be conditionally admitted, which could include mentorship, or there would be steps to remove them from the panel if their work was substandard, and if they didn't want to accept the conditions they were offered. Many actually self-selected and resigned from the panel. Many had not done a case in many years, and that is exactly who you would not want to take your case to the Refugee Board or to argue at the federal court that you should have your removal stayed. So the condition that involved mentorship was not what you would consider your usual kind of benevolent pro bono dictionary definition of an elder practitioner shaping the next generation and passing on knowledge and wisdom. The mentors through this program were actually paid. Working with them, if that was part of your conditions, was mandatory, as was the requirement that they would actually evaluate the work of the lawyer with whom they were working. One could argue, is this, because it doesn't meet the dictionary definition, was this actually mentorship or was it something else? Doesn't matter, and that could be topic for a different conversation. But you also could argue that perhaps legal aid was kind of closing the barn door after the horse had left, but not, because of course we still have refugees arriving every day and needing high quality representation. And so this legal aid depended on this assessment to know if the needs of the vulnerable clients were being served. Interestingly, one mentor that I recruited actually resigned from being a mentor, saying he did not want to sit in judgment of his peers. And I found this interesting because he was an excellent lawyer, excellent litigator, had been groundbreaking decisions in many cases, and surely had seen the fruits of shoddy representation. But, it just wasn't a role that he was comfortable with, and that was fine. This kind of mandatory and evaluative component of the mentorship did set up a power dynamic that was unbalanced, to say the least, but kind of necessary. And it's like, how do you work within that tension? Not so much among the younger groups, so you might be put on conditions with a mentor because you're brand new, but there were kind of more senior practitioners who were assigned a mentor who weren't really comfortable with it, and it did pose some conflict, and some other just kind of personal differences. Definitely, there were many successful relationships and people who've graduated and have gone off to do great practice. And some of the younger ones are often the ones who put in the most effort and time as they're learning and cutting their chops. And maybe I don't have as much time to get into this, but there was a gender dynamic in my naivete to assign, say, a 10-year-out female mentor who was an excellent lawyer to an older male practitioner. And I'm not saying when I get to the lessons learned that I would never do that again, but I might manage it and coach it a little differently. But we had some breakups along that line. So you might ask, what does this all have to do with technology? And this is where we get creative. No. There was a little bit of technology involved. So there were kind of creative or supportive resources created for this panel standards initiative. Initially, I was asked to set a series of what ended up being about 12 introductory training modules on various aspects of immigration and refugee law. And funnily enough, maybe this is where I am part dinosaur, I really didn't want those training sessions with staff recorded. I was like, no, it'll chill the learning effect. I like to be interrupted. I like it to be dynamic. No. And it was recorded 5 minutes, okay. And then that ended up being definitely the right decision, because as you have new applicants to the panel who you then could say, you can watch this video, or say articling students or new staff, it was a helpful resource for people to also go back to refresh. And for some people who either have demonstrated issues with their comprehension or that they were brand new but really eager to join, we implemented a test. So because those modules that were there, they could go away and look at them, and then I could meet with them to see and assure, for legal aid's purposes, that they knew what they were doing. And most definitely have passed, but I do have to say a handful failed, and either for not really applying themselves to the material. But you don't get a golden ticket to practice refugee law without applying yourself to get the background knowledge and learning. Also, and I know Dagmar's going to talk about this more, but kind of very happily, about half of the training modules had to be updated to keep up to pace with some of the successes to push back on those draconian changes to the law in 2012, both the federal court and the Supreme Court, so those are up to date. So I guess that's kind of technology that they're recorded and available. Also training the mentors and getting them together for conference calls. That really helped to kind of iron out some of the difficulties that were happening. Some successes, some challenges, and they came up with some pretty innovative things. Just recently I had a conference call with the mentors where they designed a form that would make some process of getting their certificate issued a lot more smooth. You know, a little bit removed from the access to justice for refugees, but keeping them happy for the important work they do was important. Doing those calls and check-ins also enabled us to really see when they might be getting burned out if they had, you know, some of the mentees, not just, some of the younger ones who were keen, but they would take advantage of the mentors and give them stuff the night before, which kind of really is not the best thing, and it's not the best use of that resource to give the best work for the client. Okay, just quickly, I have like 2 minutes, maybe? 2.5. 2.5, ooh. How to drink. Sorry. So that's that, the training and mentorship, but there's another instrument of technology that's being considered right now that of course raises concerns for me. And if you're familiar with the refugee process at all, there is a basis of claim form, which is a 12-page document that claimants have to fill out within 15 days or so of arrival. And there, not only is there that 12-page document, but refugee claimants are now also supposed to do 3 other schedule forms that, in its wisdom, the Conservative government split from one another in 2012. Hillary and I were talking in the car on the way out, and I was staggered to hear that in her analysis of some negative decisions, or don't say it again. We can't. Okay. Yes, no, nothing to say about that. See what I did when I do my hair there? No, that there definitely is, when you fracture the documentation for a refugee claimant, it makes it easier to catch an inconsistency or difficulty, especially where some of these forms are being filled out upon arrival. Right. In essence, there's a tool that I worry about. On the one hand, if you fill it out and then it helps populate those forms, and then ultimately there's a lawyer, advocate, representative checking all those forms before they go in, sure, that's a technological innovation that I think can be helpful. If in a climate of decreased funding for refugees and lack of representation, there's a push that this instrument is going to be the best thing since sliced bread for refugee claimants who, you know, have just arrived, are likely traumatized, and have to settle everything else in their lives and then think that this tool is going to help them and put it in and not be caught later in conflicts or credibility concerns for having either contradicted themselves or left something out, which is the major fodder for many negative refugee claims. That's a concern, but we don't know where that particular tool is going to go. Thank you.